guys. Hello. I am here 1 hour early. The Supreme Court oral arguments hearing only starts at 11 a.m. Eastern or 4 p.m. my time. It's currently 3 p.m. my time. But I wanted to come on an hour early so that we could discuss the case and make sure that everybody is fully up to speed with what on earth's been going on. I'm sure that most of you who are in this chat raring to go an hour early actually know, have been following everything that's gone down over the last few months. It's just gone absolutely mad. Since that memorandum came out on the 18th of September, things have gone mad. But things went even madder when the defence announced that they wanted to lock in the January 8th start date for the trial. That's when things really took a nosedive. And we had the leaks, although leaks have been coming out for many months. And some people just conveniently forget that, don't they? But yeah, this is the screen where the live stream will appear. It'll turn on, apparently, 2 minutes before the argument is scheduled to start. If you look at the website in general, I've watched a couple of these. I mean, not from start to finish, but I have watched a couple of them just to get a feel for what I've never seen a Supreme Court argument of any kind before. So I had to go and have a look to see what we were getting ourselves into. I know, I actually feel nervous. I said on my community wall a few minutes ago that I felt nervous. So what seems to happen, I watched some of this one, and there was another one further down that I watched as well. I can't remember which one now. Just like the first, half an hour, just to get a feel for what happens. And they're not long at all. They're not long. I mean, if you watch half an hour of, say, that, then it's almost over. I should have watched the whole thing, but I turned it off just before the end. So it's very interesting. Very interesting. But this is the one that we're interested in. So I'll keep that screen on. But I do want to talk through the writ and how this is going to run. So I'll do the writ first. I'm not going to read the writ like word for word, just going to skim it, just so that we're all on the same page and we all exactly know why we're here and what this particular hearing is calling for. Hope Rick is still alive. Yeah, don't we all? How long would it, if he wasn't, I mean, a serious question, if he wasn't, how long would it take for the media to find out? I mean, they'd obviously have to tell his family, wouldn't they? But yeah, so let's just assume he's still alive. Yeah, a lot of people talking about the weather. Yeah, it's very cold. It's currently, hold on, -3 here. So -2 in Leeds. Yeah, it's -3. It was -6 when I went out this morning. So for those who operate in Fahrenheit, I think that's about 20 degrees, 21 degrees Fahrenheit. Maybe. Okay. All right, so we'll start with the writ. Now, if anybody saw my video from yesterday, I read the background of the writ. So I went from what happened, like right from the start of the case. Cara Weineke and Mark Lehman gave a good overview. So from the start, from Andrew Baldwin and Brad Rosie being appointed, and then the key dates going through April when they called for a safekeeping order trying to get Rick moved, and then to October and everything that has gone down since. So I did that in that video, and I ended purposefully at the end of October, because that's the end of the background. So that's when Francis Siegel came out. We weren't privy to the October 31st hearing, because she only allowed cameras in the court for her, what she thought was going to be a spectacular disqualification on the 19th of October of Rosie and Baldwin. But they didn't play a game. They didn't play it the way she thought they would play it, I think. So October 31st was when Baldwin and Rosie turned up for the hearing. It was a scheduled hearing. Francis wanted to keep that in the calendar, and they turned up. They'd entered their appearances as his private counsel, and even though they were now entered with permission of Rick, obviously, as his private counsel, she still disqualified them with no hearing. So that's where we got to. All right. So I want to just skim through the grounds for the writ. So this is what Cara and Mark will be arguing. And the way these things go, right? So the Supreme Court have actually given them longer than normal. So they normally get about 20 minutes. Each side gets 20 minutes. But today, each side has got 30 minutes. But it's not like you can just stand there and give a speech for 30 minutes. No. One of the ones I watched, the attorney speaking, she only got, like, I'd say 2 minutes in before they started firing questions at her. And there's 5 justices sitting along the, on the bench there, and they fire questions. So it's not like they can go and just give a speech for 30 minutes. And then the other side comes up and gives a speech for 30 minutes. No. It's intense. It's intense. So Mark's going to be the one speaking, I believe, and Cara's going to be his assistant. So the judge is gone. No, not yet. Not yet. No, we've got an hour to wait. Well, 50 minutes to wait. It starts at 11 a.m. Eastern. So in 50 minutes. But we won't get the ruling today. Let's be really, really clear. We won't get the ruling today. The justices will go away and discuss it. I know, the anticipation. I feel nervous. I've actually got butterflies. There's a bunch of attorneys talking about this on Twitter. Shea Hughes, some of you might know who Shea Hughes is a defense attorney. And this is what he thinks. I don't want to predict. I don't want to predict because I don't want to jinx it. I just don't want to jinx it. Pumpkin Porter, welcome to the Secret Agents Club. Thanks for joining memberships. Thank you. Yeah, Novelist True Crime is back. Yeah, I saw his video this morning. No, Richard won't be there. No, they didn't put a transport order in for him. Tracy, member for 14 months. Oh, thank you. Yeah, I've got butterfly, and I never get nervous. If there's something going on in my life where I have to stand up and speak, I'm the most laid back person going, because I was lecturing for 25 years, 24 years. So public speaking for me is whatever. But I'm nervous. I think I'm nervous because I have absolutely no control over it. It's like, it's like I want to go there and scream at the justices and say, please, please open your eyes. Please, the world is watching. The world has seen what's going on. Please help. And there's nothing any of us can do. So anyway, these are Shea Hughes's predictions. Court will mandate reinstatement of prior counsel. Deny trial commence within 70 days. I agree with that. I think they will say that's up to the counsel to issue. To say Rick wants his trial within 70 days. That's for counsel. That's not something I don't think the Supreme Court will want to get involved in. So that one, I think I'm reasonably confident to say I think they'll deny that. Not nervous, I'm Northern. Yeah. Only Grand's member for 23 months. He's nervous as well. I know. Mandate removal of Judge Gull, appoint a new special judge. We can only hope. But that's what Shea Hughes thinks. There's a bunch of attorneys. He just happens to be one that I follow on, one that his thing came up earlier. All right, so I'm going to skim through this. Not going to read all the legal stuff, but if anybody's been really studious and gone through some of these references, then yeah, good for you. I did intend to, but I never got around to it. I'm trusting that Cara and Mark have used appropriate sources that they're confident with, and that the justices can't come along and say, yeah, you said that source, however, they really meant that. I hope it doesn't go to that kind of argument. I really hope. Anyway, original actions provide extraordinary remedies, and accordingly, writs of mandamus and prohibition will be issued only when the trial court has an absolute duty to act or refrain from acting. This court routinely relies on its original jurisdiction to address claims that attorneys have inappropriately been disqualified or that they should have been disqualified. Here, trial court has an absolute duty to reinstate attorneys Rosie and Baldwin, and the remedy on appeal is non-existent, because the argument that Francis has tried to make is that they should have just appealed. But appealing to a trial court, what's the point? Who's the trial court? Well, it's Francis. So if Baldwin and Rosie went to Francis and said, will you reconsider? She'd just say no, wouldn't she? So what would be the point? Sixth Amendment to the US Constitution provides in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. The right to counsel embraces not only the assistance of counsel, but also the reasonable opportunity to secure counsel of one's own choice. So the argument might be that he's got counsel. He's been appointed 2 counsels, Robert Scremin and William Labrato. So why should he complain? He's not in, he's not wealthy. He's not got the capacity to pay for his own counsel. So therefore, he's relying on the public defender system. And all the court is really duty bound to do is ensure that he has adequate public defense. So Francis's argument would be that he's got defense. He's been appointed 2 new public defenders because the other 2 weren't good enough. They were grossly negligent. That's the argument that they're going to use. However, the crucial, massively important thing that Rosie and Baldwin did was they entered their appearances as his private counsel. Not that they want to work for nothing. Not that they want to work for nothing. Sure, they don't want to work for nothing. However, in doing that, in entering their appearance as private counsel, it takes out the argument that these are public defenders. So now Rick has private counsel who have been disqualified without a hearing, and Rick has a right under the Sixth Amendment not only to counsel but also to the counsel of his choice. There we go. The attorney-client relationship, once established, is inviolate and should not be severed or subject to unwarranted interference. The attorney-client relationship is afforded the same venerable protections whether the lawyer is a public defender, acting pro bono, or privately retained. And Richard, very importantly, when Scremin and Labrato have contacted him and been to meet with him, he doesn't want to discuss the case with them. And neither does Kathy Allen, neither does his wife. Not that it's her choice in any way, but they're relying on this case today in the Supreme Court to reinstate Rosie and Baldwin because they truly are the attorneys of his choice. He doesn't want anyone else. He wants them, and he should be given them. And if that means that they work pro bono, i.e. for nothing, then that's what they've agreed to do. Indiana recognises only two narrowly circumscribed situations where a trial court may sever the attorney-client relationship. One, the lawyer is not a member of the state bar, so it doesn't apply. Two, the lawyer has an actual conflict of interest that will obstruct his ability to provide effective representation. Also not true. Francis did try it on in that in-chambers meeting on the 19th of October. We've all seen the transcript. We know how underhand it was. But she's tried to say that because Brad Rosie filed a notice for a civil action because of the poor way that Rick was being treated, that's a conflict of interest in Francis's mind, but not that she brought it up at the time when that notice was filed. No, she didn't bother doing it then. But she's tried to claim that Brad Rosie has a conflict of interest. No, he doesn't. Filing the notice of a tort claim is not the same as being involved in a tort claim. It's saying we are giving you notice that at some point in the future, Rick is going to get representation and he is going to file a civil suit against the Department of Corrections. Doesn't even mean to say that Brad Rosie would be his attorney. So, yeah. No Indiana court has ever tolerated a trial judge removing a lawyer from the case over a client's objection based on the judge's subjective belief the lawyer is negligent or even grossly negligent. Courts across the country regularly issue extraordinary writs in criminal cases to reinstate defence attorneys who have been kicked off cases for conduct the trial court found upsetting or negligent. So there's a bunch of cases there. Tennessee, California. Was that at Texas? Another Texas. Where's that? Is that Florida? FLA? Is that Florida? But yeah. Okay, so yeah, when a court believes it possesses objective evidence to support a lawyer's removal, it should clearly articulate the evidence on the record and exhaust other possible remedies before resorting to the removal of counsel. No, did Francis do that? No. She just decided that they were going to be removed. She didn't actually decide it, though, did she? It wasn't her idea, was it? No, it wasn't her idea. It was Slick Nick McClelland, the prosecutor. It was his idea. She just happened to agree with it. So as I keep saying, I said it in my video yesterday, and I will keep saying it, that is a very dangerous precedent to set. Very dangerous precedent to set. And surely the Supreme Court must see that. And if nothing else, they must see that a prosecutor having a hand, being given an option of an opinion either in the removal of the defence, the removal of the opposition, is incredibly dangerous. Incredibly dangerous. So the judge acted to terminate the attorney-client relationship when she had absolute duty to refrain from doing so. She had no right to do so. No right to do so. They were removed because the trial court disagreed with their conduct. The judge made a sua sponte summary finding. So basically, she just decided. she came along with her own motion saying, I'm deciding this. When actually, it was Nick who decided it. It was his idea. After the state raised the issue of disqualifying them, it's entirely unclear from the record what the court found was gross negligence. The record only includes Attorney Rosie's recollection of the acts mentioned by the court because Rick has been unable to obtain the transcript. So we do have the transcript now, and Brad Rosie's recollection of that meeting was spot on. That guy did so well. Brad Rosie, I've got a huge amount of admiration for him because his recollection of that meeting and the way he handled that meeting was so good. So good. If he hadn't handled it in the way that he did, I think it would have been a lot more difficult to get this in motion, at least quickly. But the judge's allegations fall into two categories: the mere disagreement with zealous defence tactics. That's what Nick didn't like. He probably absolutely freaked out once he realised that Brad Rosie and Andrew Baldwin were going to lock in January 8th for the start of the trial. He freaked. Amanda, member for 21 months. Squeaky bum time. Let's pray. Yeah, let's. 2, concerns about the unintended release of evidence, which subjectively had no effect on the lawyer's ongoing effective representation. So the first one was in December 2022, and it was simply a mistake. It was a mistake. Andrew Baldwin typed in Brad Rosie, and instead the autocorrect thing gave him Brandon Woodhouse, and unfortunately he sent a file to the wrong person, who sat on that for months before it ever came out. Emily, member for 26 months. Off to work. Oh dear. Nobody likes that, do they? Okay. And then the other one, of course, was Mitch Westerman, who sometime in August, so 2 months before all of this came out, so he sat on them crime scene photos for 2 months, and then suddenly decided to pass them to Robert Fortson. He ended his own life, but Robert Cohen got them and then distributed them to a bunch of people, and then it's all gone to shit. Brad is well respected in Logansport. Good. I'm glad. Seriously, I would want those guys to represent me. If I ever committed a crime in Indiana, those are the 2 guys that I'd call on. Okay, so once Rosie and Baldwin were appointed, the court lacked any authority to obstruct and sever that relationship. No, but she didn't think she doesn't think that's a thing. Indiana law doesn't matter. US Constitution. We'll rip that up. We'll only apply that when we feel it's in our best interest to do so. Reinstatement of Rick's counsel of choice is not sufficient to remedy the violation. Rick was pursuing a speedy trial and third-party guilt strategy. He intended to file a speedy trial request in early November, and once they found out, it was said in a phone call early October that Rosie and Baldwin had said, you know, we're going to lock in. We don't want any continuances. We're going to lock in the January date, you know, and they were going to issue the thing for a speedy trial in early November. But Slick Nick knew, couldn't have it. The judge kicked them off the case, rejected their appearance and struck their pleadings. This court is the only court in the state that can order a speedy trial date. If it does not seize this opportunity now, it will be forever lost. There is no post-judgment remedy available. The new lawyers have already indicated they will not be prepared for a speedy trial. The new judge should also be appointed to avoid the appearance of bias that will otherwise permeate these proceedings. Well, yeah, it's permeated quite long enough. It's been permeating away. Yeah. A judge shall disqualify herself in any proceedings in which the judge's impartiality might reasonably be questioned, including circumstances where the judge has a personal bias or prejudice concerning a party or party's lawyers or personal knowledge of facts that are in dispute of proceedings. Well, yeah. So she found the counsel grossly negligent and said she got grave concerns about their representation, you know, and she went to Rick Howell, and I'm sorry, sir. I know you want these guys, but I just can't. So if that doesn't represent bias, I don't know what does. So honestly, so I'm not going to read anymore, but honestly, I think that if the Supreme Court, if the justices feel that they have to reinstate Baldwin and Rosie, I would find it difficult for them to agree that Francis should stay on as a judge. That's as far as I'm going to go with any kind of predictions or speculations. I can't honestly see how it could work. But anyway, so we got half an hour. Has anybody got any questions? I'm just moving my washing basket. It's fallen off. This room's very precariously balanced. You wouldn't believe how much rubbish is here, and things just fall down. Yeah, so this is the live stream. So it's on the Supreme Court of Indiana website. And it's going to show there. Let's do, while we've got plenty of time, let's do a sound check, shall we? So we're not panicking last minute. So I'm just going to turn one of these on and then ask you how it sounds. And it's not fantastic audio. We always say that, don't we, with these cases? But it's good enough. All right. So let's play this one just for a couple of minutes and let me know how it sounds.
Good morning and welcome. We're here this morning to hear arguments in the case of BK and SK. We use initials because they're juveniles. Appellants versus State of Indiana. Counsel for the appellants will argue first. This is a civil transfer case. Transfer has been granted. And representing BK and SK at counsel table, we have Audrey Lunsford. Good morning and welcome to the court, Ms. Lunsford. Arguing for the state, we have...
So you're saying it's echoing? Okay, but not great. So if it's got an echo, let me do this and then try it again. It's a little low. Yeah, it is a little low, but I can turn it up my end. No echo. All right. Well, let me try this and then tell me if there's an echo.
Robert Yoke. Good morning, Mr. Yoke, and welcome. And Andrew Kobe, but you will not be arguing again. All right, counsels, we've been conducting oral arguments. You'll have approximately 2 minutes before we may start asking questions. Are you ready to proceed? All right, Ms. Lunsford.
Thank you. May it please the court, I would like to reserve 5 minutes for rebuttal.
Okay, good. So it just means I'll mute out, so there's no anything my side. I've turned the volume up as high as I can. Echo gone. Good. So we're all sorted. We know what to do. I'll just mute my mic and then there'll be no echo. Sometimes there's an echo, sometimes there isn't. And I can never quite work out in what circumstances it echoes and what circumstances it doesn't. It's weird. It's weird. But I've got earbuds in and it's really loud in my ears. So if it is a little low for you, I don't know whether it's going to have closed captions because it's live. So I don't know whether they'll be able to close caption the live. If not, then put some earbuds in or headphones on or something, because it's the sound is really quite good when you've got earbuds in. All right, so we'll go back to our boys one here and we'll wait. Yeah, earpods do help. Okay. So this is the case summary. Richard Allen is charged with 2 counts of murder, as we know. After the special judge of the Carroll Circuit Court disqualified Allen's attorneys for appointing new attorneys, Allen filed an original action petition with the Indiana Supreme Court. Allen alleges the trial court exceeded its jurisdiction by disqualifying his attorneys over his objection. Allen has asked the Indiana Supreme Court to issue a writ reinstating his previous attorneys, setting a trial within 70 days, and appointing a new special judge to hear the case. The respondent court and the Attorney General have filed responses opposing the request for writ, and the Supreme Court is hearing oral argument on the petition. So both Francis Gull and the Attorney General, Theo Rakita, can't use earbuds. They filed in opposition, but quite frankly, their arguments were terrible, really bad. You just respect from time to watch it. Yeah, I think we've all cleared our calendars. Hello, Noodle. What's up? So, do we all know why? Do we all know what we're here for? We're all good to go. Has anybody got any questions or anything? Will Gull be present? Yeah, I think so. I think her attorney's attorney. I'm expecting her attorney to appear, like speak on her behalf. But yeah, I think she'll be present. Do you think Richard Allen was held in prison to interfere with defence preparation to buy prosecution more time to try to build a case? Oh, that's interesting. Maybe, because, it's it was more difficult for them to meet with him. And it's now even more difficult for his current interim attorneys, as I call them, to meet with him. They've moved him further away. Yeah, possibly. Yeah. I don't know. I think it was to terrorize him. I think it was to put him in a place where, you know, visitation wasn't easy. Communication with him wasn't easy by anybody, not just his attorneys, and to terrorize him. And I've wondered whether it was to try to get him to plead guilty so there would be no trial, or even for him to do something very final, shall we say. Because if you're living in a state of terror, then you're just going to do what you think is easiest. And he's not broken. I mean, how he hasn't broken, I've no idea, but he's made of stern stuff. Thank you so much. Thank you so much for the 99 cents or pence, whatever you have in it. Yeah, it's cents, isn't it? Thank you so much. Remind him who's boss. Yeah. I think probably all of the above. All of the above. Do we know anywhere 70 degrees all year round? Yeah, it's probably somewhere in the world where it's 70 degrees all year round. Like on the equator somewhere, maybe. I don't know. You think that one guard needs a stint in the federal lockup? He certainly does. Yeah, the one with the face tattoo. I mean, just unbelievable. Unbelievable. Told to take his patches off, and then he goes and gets a face tattoo. They should make him wear a plaster over it. Like while he's at work. How do you not have private talks with attorneys against the law? Yeah, he's not been able to have any private discussions with his attorneys. So his attorney-client privilege has just not been afforded to him because they were videotaping his conversations. And then it's got even worse now that they're not even able to give him a room while he was at Westville. So Labrato and Scremin went to see him at Westville before he was moved. They didn't videotape, but all the guards stood outside, including the one with the face tattoo, and they left the door ajar, and they couldn't shut it. And then, now he's been moved to Wabash, and they apparently don't have a visitation room where anybody can meet privately. I can't believe that. I just can't believe it. But anyway, that's what they said. And they had him in a cell in a kitchen, and the attorneys weren't able to approach the door. They were having to talk to him through an 8-inch gap that they normally put a food tray through. And they weren't allowed to go within 6 feet of the door. How can they possibly call that an attorney meeting? And they've said that they cannot represent him under those circumstances. Crystal Moon, thank you so much. Gifted 10 memberships. Let's check out who's got them. Sharon, Jackie, your local grandmummy. Oops. Jazz King, Emmy Jo, Susan, Jill, Esme, Gypsy Girl, and another Jackie. Thank you so much. Thank you. So you 10, you get a month's free memberships courtesy of Crystal. And to find the members tab, just go to the channel homepage right here, go to membership, and then you can see a whole bunch of stuff. So cute pictures, members' lives, more cute pictures, some short videos. There's some bloopers on there as well. There's a bunch of stuff on there now. Pumpkin Porter, thank you for the $10. Thank you so much. I think there's a lot of people covering this case at the moment. There'll be about 10 gazillion people live right this very moment. I haven't checked who else has, had a scheduler up. You've been walking the grand dog. Well, the important time is in 18 minutes. So feel free to rewind, but come back in 18 minutes because that's when this starts. Yeah, Michelle's bloopers. It's basically a bunch of videos of me falling. Every time I fall when I'm filming, I now make a blooper video for members. Just cause. No, we won't get a decision today, Manchester Vicky. No. The justices will hear the arguments and then they will go away and decide. And I don't know how long it takes them to decide. I really don't know. It could be a week. It could be 2 weeks. I genuinely don't know. What are my predictions? I don't want to give a prediction. I said it at the beginning. I don't want to give a prediction because I feel like if I said I'm confident that they have to reinstate Baldwin and Rosie, I don't want to say that because I feel like I'm going to jinx it. And I know that's kind of superstitious. I think they will deny the speedy trial element of it. So them asking them to say that Rick can have a speedy trial within 70 days, I think the Supreme Court on that particular issue will say that that's not for them to decide on. So I'm not going to jinx it. But this is what they're asking for. Just quickly. So to ensure going forward, Richard Allen receives his fundamental right to counsel, a writ of mandamus is appropriate to reinstate attorneys Baldwin and Rosie as court-appointed counsel, to set a trial within 70 days from the issuance of the writ, and to remove the special judge and appoint a new one. So not too much to ask under the circumstances, in my opinion, given just how dreadful she's behaved. So you feel alive from the contemplation log. Not long after this. Yeah, I don't think I can go live on the contemplation log. I don't think I get a good enough signal. So when I talk on the contemplation log, it's always a recorded video. Maybe one day I'll try to go live on the contemplation log, but I think it'll just be frustrating because people will be like, I can't hear you. It's not good enough. Hey, Jean, thank you for the €10. Thank you. He is innocent till proven guilty. Needs to be in a county jail. He absolutely does. He needs to be treated like any other pre-trial detained person. So someone who has been denied bond or can't make bond, you're on remand in a county jail. It's so funny when I say, Francis, come on, Francis, come on. Oh, dear. His win is everyone's win. This is the thing. At this moment in time, it's completely irrelevant whether Richard Allen is objectively guilty. Like, he actually did it. He actually murdered Abby and Libby. It's irrelevant at this moment in time. Not just because he's innocent till proven guilty in a court of law, not just because of that, and that is a right of everybody to be innocent until proven guilty in a court of law by a jury of your peers. But it's gone way beyond that now. Way beyond that now. Thank you, Grey Wolf Paranormal, for the $5 Canadian. If it doesn't go well, millions of people will lose faith in the justice system worldwide. You're not wrong. You're not wrong. And surely that can't be lost on the justices of the Supreme Court of Indiana. Because it's not just the right to be innocent till proven guilty in a court of law and convicted by a jury of your peers. It's not just that. It's that his rights of being, as a pre-trial detainee, they've been ridden roughshod over. His treatment has been diabolical in a state prison. Diabolical. He's not been allowed attorney-client privilege. Now his attorneys have been disqualified for no reason whatsoever. The judge is biased, and the prosecutor, in my opinion, is pulling the judge's strings. That's just my opinion. Thank you, Estelle. Thank you so much for the 140 South African Rand. Thank you so much. Let's go. Yeah, let's go. Let's go. How long have we got? 12 minutes. I'm so nervous. I feel nervous. I can't believe I actually feel nervous. But this could be, right, listen, it's not about Richard Allen's guilt or innocence. It's not. He could have been the most guilty person in the entire world. Like, it could have been overwhelmingly obvious that he was guilty. You know, like, some cases are just overwhelmingly obvious. Like, at the moment, we've got Adam Montgomery, who I can quite confidently say murdered his daughter, Harmony Montgomery, at the age of 5. Thank you, Robin, for the $20. That's very kind of you. Thank you for the avocado. You know, there are some people, you look at the case and you think, you're guilty. You're guilty, right? And it's just, the trial feels like a formality. I know anything can happen in a trial, and it is down to the jury. It's down to the prosecution to prove the case beyond a reasonable doubt, and it is down to the jury to decide. But there's some cases where you think, you're guilty. You're guilty. I don't need a jury to tell me you're guilty. But I would have still said that this is wrong. This is wrong. This is not justice. Because if you cannot have a detainee, a defendant, who is afforded a fair trial, then it can wrap the legal system up for years. For years. Because he's got grounds for appeal after appeal after appeal after appeal. If you watched Crime Story Sunday back last week, a few days ago, the case of Jill Dando here in the UK from 1999. And the police basically fitted up a guy who, you know, fit the bill as being a bit of a weirdo, a bit of a loner, and they weren't getting anywhere with the case. So they pushed through this prosecution, and it ended up being an 8-year battle, and he eventually was acquitted, and rightly so. But it wraps the legal system up for years and years and years, which means that any decision that comes from a trial that's been unfair is not justice for the victims or their families. So in my opinion, Richard Allen has to be granted justice before Abby and Libby can be granted justice. So if you want justice for Abby and Libby, and if you're here listening to me right now, I'm sure you do want justice for Abby and Libby. That's what we're all really here for, isn't it? Justice for Abby and Libby and their families. But without justice for the defendant, without having a fair trial for the defendant to be able to, go to trial with a quality defense, and if he's found guilty after a quality defense and the prosecution is able to prove beyond a reasonable doubt that he did it, then lock him up and throw away the key, in my opinion. But until then, he is innocent until proven guilty, and he needs to be afforded the rights of any other pre-trial detainee across the world, right? In the free world, at least, in my country, right? It's the same, essentially the same legal system as in the US. We have the same rights. We don't have a constitution, but the right to a fair trial goes back to the, 1215 and the Magna Carta. We can go back all that way. When King John was forced to sign the Magna Carta, the Great Charter. All our legal system comes down from that Great Charter. But, yeah. In 1215, they realised, 1215 AD, they realised there had to be some kind of written down rules for the justice system. And it's been developed since then. It's very basic. You're innocent till proven guilty in a court of law. You can't be imprisoned unfairly. And if you are imprisoned, you have to be convicted to be imprisoned, right? For the rest of your life with no end in sight. You can't be an innocent man with no end in sight without a fair justice process that backs you up. Anyhow, much more faffing about in the US. I think, honestly, I think there tends to be a longer process in the US. Not always, though. I mean, think Alec Murdoch. Like, he was only arrested in. Hold on, when was he arrested? But his went to trial very quickly. I can't remember now when he was arrested, but his went to trial very quickly. And in the US, if they exercise their right to a speedy trial, then that has to be done. It's only if they waive their right to a speedy trial that they can kick the can down the road. And it's usually both sides kicking the can down the road. Quite often, it's the defendant's side kicking the can down the road. Look at Sarah Boone. At the moment, she's on a seventh defense attorney, and her trial's been continued again. It's due to start in March. It's now been continued till May, I think. So yeah, there's a lot of faffing here as well, to be fair. There's a lot of cases that get kicked down the road here. I mean, the trial that I was a jury member on, that came to court quick, because it happened on the bank holiday weekend in August. So that'd be the last weekend of August. And the trial started on February 24th. So, yeah, 6 months. Hold on. September, October, November, December, January, February. Yeah, 6 months. Only took them 6 months to get that to trial. We only have a few minutes, I know. So will this thing just like turn itself on, or will I have to keep refreshing? Will it just start at 11? It says here the video player will be available 2 minutes before the argument is scheduled to log in, to begin. I read that as login then. So in a minute, I'll refresh the screen and see whether we're on. Because I don't think it's just going to turn on itself. It might do. I'm so nervous. I'm so nervous. But I'm going to try and really, really listen. So I probably won't comment much in the chat. Because this is why I watch a lot of live streams. Even if I'm on a like watching actual live, usually on the replay because I'm asleep or something. But you don't often see me in chats, even if I'm watching live, because I can't concentrate. I can't concentrate on the chat and listen at the same time. All right, let's refresh here. Oh, here we go. Ooh. Right, we're on. I'm going to mute out now. All right, so I'll see you on the other side. Thank you, Helen. Another hat coming me next week. Thank you so much. Right, I'm going to mute out so there's no echoes.
Good morning and welcome. We're here this morning to argue in the case of State ex rel. Richard Allen, relator, versus Carroll Circuit Court and the Honorable Fran M. Gull, respondents. Counsel for Richard Allen, the relator, will argue first. We're hearing this case on a writ for mandamus and a prohibition case. Representing the relator today, we have Mark Lehman. Good morning and welcome, Mr. Lehman. You'll be arguing the case. At council table, we also have Kara Winnecke. Good morning, Ms. Winnecke, and Bernice Corley. Good morning and welcome, Bernice Corley. Representing the state of Indiana, at council table, we have Angela Sanchez. Good morning, Ms. Sanchez, and welcome. You'll be arguing first, correct? Second, all right. You're just listed first on the appearance. Got that. So Matt Gutwein, you're representing Judge Fran Gull, and you will be arguing first. And at council table, we also have Chris Stake, who's also here on behalf of the respondent, correct? Good morning and welcome, Mr. Stake and counsel. Counsel, as we've been conducting oral arguments, you'll each have about 2 minutes before we may start asking questions. Each side has 30 minutes, so you ready to proceed?
I am, Your Honor.
All right, Mr. Lehman.
Good morning, Justices. No Indiana court has tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or being ineffective. Cases across the entire country do not tolerate the removal of the entire defense team from a case over the client's objection where the lawyer is licensed in the jurisdiction and prepared for trial on the scheduled date. When a judge severs the attorney-client relationship over the client's objection, the integrity of our entire judicial system is undermined, and the unauthorized action necessitates that this court intervene and invoke its inherent authority to supervise the conduct of lower courts. On October 12th, the judge ordered counsel to, quote, cease work on Mr. Allen's case until we meet on the 19th. This was a period where intensive work was occurring in the case, where Mr. Allen and his lawyers were in the middle of tactical decisions and strategy review. This impied the right to counsel. When October 19th rolled around, the judge took clearly coercive action to sever the attorney-client relationship on her own motion. The judge was without jurisdiction to sever the entire defense team over the objection of Mr. Allen's wishes. And his licensed counsel, who both remain in active and good standing in our state.
Without jurisdiction? Explain that. Why was the judge without jurisdiction?
Judge, I think the judge here exceeded her jurisdiction when she refused to accept Rick Allen's wishes when she had an absolute duty to act upon them. And the judge crossed the barrier of neutrality and entered the realm of being an advocate. And when the defendant is saying, this is what I want, this is what I desire, that the judge is without jurisdiction and has an absolute duty to act upon the client's wishes under those circumstances.
So isn't your argument more accurately phrased that she's under a duty to let them back into the case? It's not a question of court's jurisdiction being exceeded, is it?
No, Judge, I see those as one and the same.
Are you talking about authority or jurisdiction? I mean, we have a lot of cases that define both of those differently.
Judge, I think that under either construction, and I see this as the judge is without authority, or excuse me, the judge is under an absolute duty to act upon the wishes of the defendant under these circumstances.
Okay, but you don't cite a lot in that. So when you talk about absolute duty, a court, we have cases that say courts can remove counsel for various reasons if they're not a member of bar, if there's a conflict that really is to the detriment of the client. So there's not an absolute duty to always leave counsel on, correct? There is some discretion the trial court judge has.
There's an absolute duty to follow the client's wishes. And then when a conflict of interest arises, the issue is whether the client fully understands that whether he's making a knowing and voluntary decision.
And the absolute duty is found under the Sixth Amendment?
Judge, I think the absolute duty could just be under this court's case law, but I think that in the aggregate, that the three violations of the Sixth Amendment provide this constitutes three situations where in their totality, they clearly place the limit on the judge.
Is there a reason why you didn't file a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
Judge, we didn't feel like we had the record to preserved that issue and developed a separate argument under the Indiana Constitution. But we're not arguing that this court isn't free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that You
have a lot of concerns, but I've got a couple. You've got a lot of concerns, and you do a nice job laying those out in your brief. But there's a couple of things. You're asking the court to issue a ruling for a speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So, correct?
Yes, I think when he signed it, they were outside of the 70-day, but the speedy trial.
But you acknowledge that you're asking us to to grant something that wasn't requested at the trial level?
Well, it wasn't requested at the trial level, Your Honor, because it wasn't necessary until October 31st when the judge removed them the third and kind of final time.
So they
from
sat
being
on it for they had it for 2 months and didn't file it. Your client signed it in August under the.
Yes, Your Honor, they had it and did not file it. One, there wouldn't have been a reason to file it. They had it made. So the speedy trial was an intimate part of their strategy here, and they had developed strategy and tactics with Mr. Allen as to when specifically to file that. The request for the completion of discovery was granted by the judge. That deadline was submitted or ordered by the court to be November 1st. And then the tactic there would have been to file for a speedy trial right after that to lock in the trial date and to close down the evidence that the prosecutor can then introduce at that point. But Your Honor, that request is because it's the relief that our client wants, and so we needed to present it to this court. Obviously, if this court reinstates attorneys Baldwin and Rosie and orders the judge off the case, that if we proceed forward with the trial, that they can refile that with a senior judge who would take over the case. But the relief that Mr. Allen wants is he wants attorneys Baldwin and Rosie on the case, and he wanted a speedy trial. And in order to show that that's an intimate part of the trial tactics and decisions that were going on was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
First, Justice Slaughter, she's not right about those findings. Second, there isn't a record to even substantiate those findings. But third, those issues don't involve.
If there's not a record, maybe then the findings aren't proper. But if the findings are correct, why doesn't what she did follow from those findings?
Because the client has the autonomy to choose the direction of his representation. And if he is aware that there may have been some sort of violation, or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the lawyers that he has developed a relationship.
Concern? Waive any, for example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceeding on his behalf, if they go to trial, he may well have built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you suggesting that your client would waive whatever Strickland violation might occur were he to proceed to trial with these lawyers?
Judge, that's almost essentially what happened with regards to the disclosure of the Westerman materials. He filed with the judge, says, I'm aware of that. I know what's happened. I'm ready to ride or die with these lawyers. I'm just asking you to tell us on the record whether that's something you're asserting on your client's behalf. If we grant the relief you want, there will be no Strickland claim that can be asserted because you're waiving it. I think on the if the judge was to build appropriate record, that can happen. The judge, that's what happens in all conflict of interest cases, and that's what happens under this court's case law. You bring the defendant into chambers, you say, listen, in Lada, he's representing the wife, he's representing you, or excuse me, he's representing your husband, ma'am, and he's representing you. Do you fully understand that by proceeding forward, that could cause some problems for you? And he may not have fully disclosed those to you because his interests, his loyalties are divided.
Well, if I hear what you're saying, you're invoking your client's right to counsel of choice, but you're disclaiming your client's right to competent counsel if and when he goes to trial.
Disclaiming, no.
You're waiving your client's willingness or right to invoke a Strickland argument on collateral review.
The client can knowingly and voluntarily waive conflicts of interest, and he can waive certain issues for collateral review. Absolutely. But none of that happened here because the judge didn't hold a hearing. The judge didn't hold a hearing and say, listen, I feel like this pretrial publicity somehow a year ago is going to contaminate your trial.
Counsel, we're not talking about waiving conflicts of interest. We're talking about waiving ineffectiveness.
Yeah. None of these things that the judge is citing have anything to do with ineffectiveness of trial counsel at trial. Ineffectiveness is not coextensive with ethical violations.
She thought his representation was grossly negligent and incompetent.
She said you're grossly
The- the-
negligent and
the
incompetent.
lawyers-
I don't know if it was about trial representation at all. And in the arguments that she advances in the brief regarding what she says is grossly negligent and incompetent have nothing to do with whether a fair trial is going to happen here. And if there was a hearing where these matters were discussed and fully vetted, that either the client could waive any Strickland issue as to those issues, or the issues would be proven that the judge there's no foundation for the concerns that she's had.
Mr. Lehman,
Yes, Judge.
that's really what I'm struggling with. Our original jurisdiction is very limited. And so if we were to agree with you on the substantive arguments that you've made, why is it that the regular appellate process is wholly inadequate?
Justice Goff, interlocutory review and direct review are impossible and don't get us anywhere near the relief that my client's entitled to. My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy of third-party guilt and a speedy trial to catch that prosecutor on their back foot. And it was blown out of the water from a judge who exceeded her authority. And so we would have began that interlocutory review process by putting a motion in front of the judge, asking her to certify an order that we weren't even sure what her order was, but she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties, and that was even with the judge asking for an extension of time. This gentleman had attorneys Balden and Rosie, who he'd been working with for over a year to develop and get ready to catch that prosecutor on their back foot with a well-developed third-party guilt strategy that was to be going now.
Wait, Mr. Lehman, we would have a full record if they hadn't agreed to withdraw, correct? It would have gone to hearing?
I don't think they would have had a full record even then, Judge. The judge was saying that there was a coercive action, the judge. I'm going to go out there and I'm going to say these things. And Mr. Rosie presses at her. Well, what's that proceeding going to be? And the culmination of it that the judge says, the culmination is you're removed. So the record, I don't know, would have been any better. And in fact, it would have harmed Mr. Allen even more because it would have put on the public record the judge's personal bias towards the strategy that he had developed, which is a strategy of these two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we believe, Your
Because you're
Honor,
saying there's not enough for this, but there is enough for that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
correct, Your Honor. I do think I don't think
Got a
those positions are inconsistent. That there is no evidence of incompetence, certainly no evidence of trial incompetence, which is what the Sixth
My
Amendment
concern is getting
requires.
this case back on track. All
Yes.
right. So your argument is that you have a constitutional right to counsel of your choice in this circumstance, and you acknowledge there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's structural error and it'd be reversed and everybody would have to go through this again, correct?
Yes. Judge, but I do want to clarify that this is more than just a choice of counsel case. Like, this is an interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the case, whether we go into the courtroom or you stay in here, you're off the
A
case.
lot of events in this case that led up to that hearing, correct? With regard to sending information on a case to another criminal defendant, with regard to, well, there's a lot. I don't need to go through it. It's in both your briefs. So there's a lot of questionable things that have occurred up to this point with regard to the release of discovery or letting third parties have access to discovery. Is there no line that a judge, let's say that everything was turned over and counsel didn't show up for hearings. Is there ever a line that a trial court judge has to say, listen, I know this is your court, at this point, a court-appointed counsel. I do not think you're going to fair trial and you're going to set yourself up on the flip side for reversal, just like I talked about the structural error being grounds for reversal the other way. You're going to come in on a Strickland ineffective assistance of counsel and say, my attorneys were not affected. I mean, I lost, and this is because my attorneys did X, Y, and Z.
Yeah, the not showing up for hearing is a unique situation because one is the lawyer is not being a lawyer at that point. They're not being,
Not filing briefs, not meeting deadlines, not submitting a brief of AI that doesn't make any sense.
So, Judge, if a judge is exhausting other remedies short of disqualification, extreme misconduct will eventually fall into one of our other categories. That is, the client will object to the continued representation, that the lawyer will be removed from the case, excuse me, the lawyer will eventually himself pull out of the case or a conflict of interest will develop. And we see that in some of the other cases across the country. And so, like, if a lawyer in one case was obstructing justice, he was literally going behind the scenes, talking to co-defendants who were represented, trying to manipulate their testimony. The judge at that point just proceeds forward with the law on conflict of interest. It says, calls forward those witnesses, said, did this lawyer try and obstruct justice? Did he try and commit a crime? And then at this point, a conflict of interest occurs because then the lawyer can't advise the defendant to take a plea because for fear he might himself be more criminally culpable.
But you believe that all conflicts are waivable. Am I understanding your position right?
I think there are rules that an actual conflict of interest is unwaivable when you sue one party versus the other. And shockingly, that seems to have happened in one of the cases in Indiana. But other conflicts are waivable conflicts, and other than that one rare exception of.
And I'm still a little confused with the exchange with Justice Slaughter about the waiver. So let me ask it this way. If we grant you the relief you're requesting, we reinstate counsel, and Mr. Allen's convicted, can he pursue through PCR, post-conviction relief proceedings, a claim that his counsel were ineffective for the very same reasons that the trial judge here found?
So the trial judge here found that he can't, it depends on what record the court would build regarding those, but no, I'm going to change that, just no, because these issues have nothing to do with effective representation at trial. So I don't think he could pursue them on those grounds. But so I don't see how these three violations, the inadvertent disclosure of pretrial discovery, that the press release over a year ago in direct response to press that the government was putting out, I don't see how those issues affect his trial. So I don't think he gets a post-conviction relief through that because those issues don't affect trial strategy.
But you're saying he would lose on the merits. You're not willing to concede that it would be waiver. And it seems odd that he could have it both ways, that he can say, you can never remove my counsel over my objection. I object, but then still have available to him the argument later that, well, even though I objected, it was still ineffective.
If the judge exhausts, I think the judge can take care of that. The judge can call, say, let's have a hearing regarding that pretrial publicity and somehow establish that that might be affecting his trial and that fully and fairly advise him that that's a repercussion. But when he's fully and fairly advised of that, the repercussions of that judge's subjective belief that there was somehow some sort of ethical violation there, I think that he would be waiving it. So,
well, counsel, are you arguing that the record doesn't support a finding of ineffectiveness by the trial judge? Or are you saying if the judge finds it, she still can't remove him?
Both. This record does not support ineffective assistance to counsel.
But even if it did.
No, sorry. The reasons that she advances aren't reasons to find a lawyer ineffective. Now, if this court was to say those are reasons that a law that would constitute ineffective assistance of counsel for a Sixth Amendment violation. So if we were to get to that point and he was fully and fairly advised of the potential repercussions of those violations on his trial strategy, then you could have a waiver issue. But the reasons that she cites for doing what she did have nothing to do with trial. But let's assume for a moment that she cited a reason that there's an intimate relationship going on. And she pulls them in, goes into the chambers and says, listen, I understand that there's an intimate relationship occurring between the defendant and you. Do you understand that's a conflict of interest? That's a violation of the ethical rules, that there's a disciplinary proceeding that I'm going to be referring for him. Do you want to go forward with this representation? And the client says, yes. I think you've got a waiver of ineffective assistance of counsel on those grounds, but I don't think that the judge is absolutely precluded from injecting herself and saying, well, that in that case would be a conflict of interest. So we're struggling to find a situation where there's an ethical violation that affects the outcome of trial, where there's a situation where the defendant says, I want to go forward, I've been fully and fairly advised of it, and the judge somehow has a role, absent a conflict of interest, injecting herself into that. And I do think that you can waive, you can waive an ineffective assistance of counsel claim. That's well-established case law. It's just none of these things the judge cite have anything to do with ineffective assistance of counsel. These are purported ethical violations, and not every ethical violation necessarily, even if it was established, has anything to do with trial strategy and whether a defendant receives a fair trial. And these are examples, these are good examples of that. In that the inadvertent disclosure of pretrial discovery has not, the alleged violations here would have nothing to do with the trial strategy that attorneys Baldwin and Rosie developed with him, and would have no impact on that case.
Mr. Lehman, let me just sort of ask with respect to the line of questioning, if we were to agree with you and find that there was inadequate reason, at least on the record, to allow for the removal or the refusal for counsel to reappear, nothing would stop the trial court from making a more complete record and going through a different process if in fact it believed that there were sufficient reasons to remove them. They just weren't adequately reflected in the record.
Judge, I think a court has broad discretion on how it conducts proceedings in the courtroom, but none of the reasons that she cites in her brief would allow would even if found would substantiate the removal.
But if the court were nonetheless worried about the finality, the eventual finality of the proceedings, and wanted to nip a problem in the bud, is there anything that would stop her from conducting a proceeding on remand or similar to prevent
No,
that from happening?
I think if there's a concern, say, for example, the pretrial publicity, the press release, if you say, listen, I think, because the violation says it has to affect a fair trial. So, okay, you're going to have a hearing, the judge could have a hearing, let's provide proof or get some sort of sense as to how this has affected the jury pool or what prejudiced the jury pool. I assume the judge could conduct some sort of proceedings to investigate that. But if the client is fully and fairly aware of those proceedings and still wants to proceed forward with these clients, then the judge has an absolute duty to accept or to act on his wishes.
Counsel, Mr. Lehman, is it your belief that if we deny the extraordinary request that you've sought today, and if the case goes back to trial with a different set of lawyers that this defendant just does not want, that there is built into that record at least fundamental error, maybe structural error that's reversible?
Trials for show. It's a practice only trial, Judge. I think, and that's why we came here as fast as we could, because if we do not get something done now, the victims are going to be hurt, the public's going to be hurt, the entire Indiana judiciary is going to be harmed because this trial's been pushed off till October. And when the judge said it in October of 2024, one of the lawyers, I believe, even represented, he didn't think they were going to get that date either. Everybody's hurt, and we're going to delay things.
And you think the Gonzalez-Lopez precedent of the U.S. Supreme Court would dictate that outcome?
I think it's structural error, yes. So, and that this trial is going to be for practice only, and we have built-in error, and the only way we can fix it and address the speedy trial problem, because that was an intimate part of the trial strategy, is to get attorneys Baldwin and Rosie back on the case and get this case set for trial in a time frame that's as fast as our law allows, which is 70 days. And that's what the relief we're requesting. Thank you very much.
Thank you, counsel. We'll hear from you again on rebuttal. Mr. Gutwein.
Chief Justice Rush, and may it please the court, I am Matthew Gutwein, representing respondent, the Honorable Francis Gull. This court should deny the petition for 3 reasons. First, the trial court's decision to remove Mr. Allen's counsel was an exercise of discretion, and this court has uniformly held that a writ of mandamus will not lie in matters that rest with the trial court's discretion. Second, Mr. Allen's remedies on appeal are not wholly inadequate. The United States Supreme Court and Indiana's appellate courts have regularly resolved Sixth Amendment claims, such as those that Mr. Allen raises here, through the ordinary appellate process. And third, on the merits, in removing Mr. Allen's counsel, the trial court did not abuse the court's discretion. The trial court has significant latitude to prophylactically prevent a violation of Mr. Allen's constitutional right to effective assistance of counsel.
Counsel, is that really what's going on here? We don't have a great record before us on which to make these judgments, but reading what we have, I'm left with the impression that it's quite possible that two different concepts, ineffectiveness and insubordination, are being conflated here. There seems to be a great deal of concern by the judge that these lawyers were flouting her gag rule and that they were insubordinate. But where's the evidence in the record that they are constitutionally ineffective? I mean, the order seems couched in that language that we're trying to protect the defendant from his own lawyers. But it's hard to look at this record and not get the impression that perhaps rightfully so, the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under the United States Supreme Court decision in Wheat, the trial court, in exercising her discretion to remove counsel, does not need to find constitutionally defective counsel. It does not need to require ineffective counsel. Rather, as in Wheat, there just needs to be the possibility of ineffective assistance
But I'm really
of counsel.
struggling with that. I'm, butting that up against the Sixth Amendment constitutional right to counsel, and particularly when they filed the second petition of filing as private counsel of their choice, that's structural error. And I agree, it is. Okay, you can shake your head, but I'm reading the Justice Scalia and taking him for his word on what that is. And how do we get this case back on? So we have that hearing. You have issues with regard to, well, you gave a press release. Well, the gag order was after the press release. You've got, well, we don't like, what you filed in, I think it was in June, with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. We have in the record now, because we can take notice, there's a new motion to transfer Mr. Allen filed by his current attorneys. So we don't have a hearing. We don't have findings. You've got a constitutional right to counsel. And he's choosing this counsel. You have a constitutional right to say, I don't want an attorney, correct?
Under Wheat as well as Lotta, this court's precedent, he does have a constitutional right to select counsel, but that constitutional right is highly limited, and that right may be outweighed by any number of interests.
But counsel, you're a very, and I'm quoting Chief Justice Shepard in the Knox case saying, a judge has a very limited right to tell someone who their attorney can be. They just decided not to go the parameters there because there was an agreement to withdraw.
Wheat says the opposite, Your Honor. Under Wheat, the trial court's discretion when faced with the balance between, on the one hand, counsel's right to select counsel, and on the other hand, counsel's right to effective assistance of counsel, what Wheat says is the trial court is to be given substantial latitude, is to be given wide latitude. What Wheat says is that decision is best left for the intuition and judgment based upon the experience of counsel in weighing those competing rights. Wheat says, in a highly deferential standard, that the issue of whether trial counsel should be removed must be primarily resting.
And I don't read Wheat, and I looked at Wheat several times as strong as what you're doing. And I think what you're doing is you're butting right up against a constitutional protection, and you're doing it at your peril, and this court would do it at this peril with regard to a case possibly having to be tried twice and having everybody going through that again.
That exists either way, right? In other words, as this court has already identified, if the trial court, if Judge Gull does not remove counsel, then counsel has the possibility of raising an ineffective assistance claim.
But isn't that a really good reason for us to just go ahead and address the merits? I mean, I'm a little confused why the respondents don't want us to address the merits. I mean, I realize you think there was no mistake, so why not ask us to just say that? And you're certainly right that we have plenty of cases saying in original actions, we don't review discretionary issues, especially not issues of first impression. But I think I found at least 4 cases where we went ahead and did exactly that. We've looked at attorney disqualification issues, including issues of first impression. So why isn't it in your client's interest to just get an answer from our court one way or the other, whether this was error?
Well, I do think that it would undo enormous amounts of procedural law on original actions. I mean, this case has so many procedural hurdles, that Mr. Allen cannot scale based upon the procedural requirements. And I don't see how this court could exercise a limiting principle that somehow it's perfectly fine to grant the writ when this is a matter of discretion. The court doesn't grant writs for matter of discretion. There's a remedy on appeal. The court doesn't grant writs for remedies on appeal. They never specifically even asked for this relief in the trial court. The court doesn't grant writs. So I think you would be doing structural damage to your original action jurisprudence, and frankly, then open up the floodgates, because these kinds of pretrial claims of constitutional violation are extremely normal. They are extremely rare. And if this court wants to get in the business of addressing the merits every time a criminal defendant raises a pretrial constitutional violation, you will be flooded with these kinds of actions.
So
Well,
your
tell us why you
solution,
think that counsel's, Mr. Lehman's argument that no meaningful appellate right exists is just wrong from your perspective.
Well, that is absolutely wrong. And Hannah reflects that. Hannah is an interlocutory appeal on a claim for a violation of the right to select counsel. And on that interlocutory appeal, the Indiana Court of Appeals found there to be a violation and restored counsel. There can't be any serious question that these kinds of claims for Sixth Amendment violations, right to select counsel, are resolved on the ordinary appeal process. In fact, every single United States Supreme Court case to address the issue of the right to select counsel made it to the United States Supreme Court through the ordinary appellate process. And the Supreme Court had never so much as even hinted that the relief on appeal is somehow inadequate for a Sixth Amendment
And just so
violation.
I'm clear, what you're talking about in the ordinary course would be a final judgment. He goes to trial with different counsel, he's convicted, and then you go up and appeal in the ordinary course?
No, not necessarily. I mean, here, there are interlocutory appeals, there are emergency interlocutory appeals, there are appeals after final judgment, there's appeals on PCR. And we have examples of all those cases. The absolute fact is that the ordinary appellate process offers a wide array of avenues for Mr. Allen to seek relief for his constitutional violation, and he has availed himself of none of those avenues.
What about our 1982 precedent? So State versus Tippecanoe County, the shoe was on the other foot. It was the prosecutor's office that was disqualified, and the prosecutor sought a writ in our court. Now, we denied the writ, but we said that it was an issue of first impression. We reached the merits, and we gave the state the answer that it wanted through an original action.
Let me answer that in two ways. First of all, you've already identified this court denied the writ in that case. And second, there is no discretion for a prosecutor who has a conflict to prosecute a case. And in that case, the trial court had no discretion, had an absolute obligation to remove a prosecutor who has a conflict. That is not the case here. Under the United States Supreme Court's jurisprudence in Wheat, the decision to remove counsel based upon the possibility, based upon the potential for there to be.
but it has to be done, there's a way that you do it. And it does not appear this was done the proper way. You're supposed to have a hearing. The court did it sua sponte, which means on their own motion. There was a hearing in chambers. So did she exceed her authority by the manner that she presented them back in chambers, saying, you're either out or I'm going to publicly out you?
Well, there's certainly no U.S. Supreme Court case law or Indiana case law that says there has to be a certain amount of procedure.
So there's no process involved at all for taking a judge, no hearing, no, I have the suspicion that this is going on. I think you're incompetent and you're out.
Well, the trial judge was prepared to have a hearing here. A hearing was scheduled. Counsel had notice of a hearing. The prosecutor was there ready to present witnesses. And the counsel in this case made their own strategic decision to withdraw rather than go out in open court and have a hearing. And that was their choice. And they made that choice, I'm sure.
Having read the transcript, was it a full and free choice?
Well, these are very experienced lawyers. These are highly competent lawyers in other contexts. And they had notice that the judge was considering disqualifying them. They had notice on October 10th when the judge told them that she was considering disqualifying them. They were leaning in that direction. And between October 10th and October 19th, an awfully lot of lawyering occurred. On the 11th, Mr. Rosie got together with their client and drafted a letter. On the 12th, Mr. Rosie filed a highly detailed letter with the court offering his defense and asking not to be disqualified. Sometime before the 19th, Mr. Baldwin hired outside counsel. On the 19th, outside counsel filed a brief. They had oral argument. There were 9 days of an awfully lot of lawyering that occurred in that period. And at the end of that, what both counsel elected to do was state their intent to withdraw. And Mr. Rosie said, I've got a life outside of this case. I've got a life outside of this courtroom. I have a family. I have a law practice, and I'm going to withdraw. And that is his choice. That is his decision to do that. But if they had wanted, they could have filed for a continuance. They didn't do that. They could have gone out and had a hearing and presented evidence. They didn't do that either. What they
Would
did
any
was
of those
withdraw.
actions have been non-futile? I mean, I thought the judge made clear that her mind was made up. She had prepared a script. She'd already made the decision. If they wanted a hearing, they could get it, but there was no opportunity to persuade her. Did I misunderstand?
We'll never know, right? Because there wasn't a hearing, because counsel elected to withdraw.
You do know, because she said then at the hearing on the 31st, what's changed? So, which means,
Well, we won't know
do
what
know
would have
that.
happened at a hearing that never happened, but you're right. I mean, I certainly acknowledge that she probably wouldn't have changed her mind.
Counsel, I appreciate you looking out for our original action jurisprudence and our potential future caseload, but as long as we're here, what can you tell me, what can you point to in the record that supports a finding that these lawyers were ineffective to the point where they needed to be removed to protect the rights of Mr. Allen?
Again, under Wheat, there doesn't have to be a finding that they were actually ineffective. What there has to be a finding of, and this is under Wheat, that there is the potential to be ineffective. And here, it is not within the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material
Can
and
you help me
attorney work product.
Can you help me understand how that hurt Mr. Allen's defense?
Well, believe Mr. Rosie. Mr. Rosie himself said the likelihood of public backlash is significant, and this leak serves no legitimate public purpose. The reality here, as we all know, is that we already have a polluted jury pool because of the inordinate pretrial publicity that this case has garnered. And the further disclosure of highly confidential inflammatory material further pollutes that jury pool, making it that much greater to have a fair trial for Mr. Allen. And the trial court is rightly and appropriately able to exercise under Wheat, and I quote, intuition and judgment based upon experience, to find that if counsel is capable in the pretrial stages of making this many mistakes, what manner and magnitude during trial is counsel capable of
I keep getting
making?
back to it, and I understand what you're saying, but I keep getting back to, if a criminal defendant has a constitutional right to say, I'm going to be my own attorney, well, that's fraught with more than just what we're talking about here. He wants these attorneys. And so we're spinning and spinning and spinning on this, saying delay and this, but he wants these attorneys. There's not been these findings with regard to incompetence. There's a lot of words out there, but let him have his attorney. Get this case back. Let him have his attorneys. He wants to privately hire them. I'm really struggling with why he can't make that decision that that's in his best interest and get this case moving again.
Let me answer that in two ways, Your Honor. First, again, in Wheat, the accused in Wheat, Mr. Wheat, knowingly and intelligently waived the conflict in that case. And there was only a potential conflict. Wheat
It was
waived
a
that
major
conflict.
conspiracy with lots of different people playing, in the Wheat case.
Wheat
I don't see
himself,
Wheat as tucked as neatly as you find Wheat. So
Wheat
go
him-
outside Wheat and give me something else.
well, but again, Wheat himself claimed that this conflict was highly remote, highly unlikely to occur. Very small chance that the conflict will ever occur. And he waived the conflict, and yet the trial court found, based upon the court's intuition and judgment, based
But
on
where can you point to me saying, with regard to saying somebody is incompetent or negligent? That's like, we have a string of cases. So these conflict cases have come up before with disqualification. Where are we on this?
Well, again, it is certainly not consistent with the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material that will pollute the jury pool. And here we already have a jury pool that is polluted.
Does that rule apply both ways? Because one of the things defense counsel said in their letter to the court was that they believed that the state had allowed the dissemination of information regarding the crime scene. So can a judge disqualify the prosecutors too?
Well, again, the judge certainly could disqualify the prosecutor. We don't have any evidence in the record. We have Mr. Allen's counsels asserting that. There's never been a hearing on that. There's never been a finding on that.
I'm just trying to understand the scope of the rule and how sharp of a double-edged sword that this might be, that any leak of crime scene photos or anything like that can lead to the disqualification of counsel on either side, I think is your position.
Well, Your Honor, our position is under U.S. Supreme Court precedent, as well as this state's precedent, this court's precedent, the trial court is vested with discretion. And even Wheat said that faced with the same facts, one court might find disqualification appropriate, another court might find it not appropriate. But because two courts could reach exact opposite decisions in matters that rest with discretion, doesn't make one right and one wrong. So I'm not suggesting, nor is Judge Gull suggesting, that there's an absolute rule here that every time there's an unauthorized disclosure, that gets into the discretion of the trial court.
You would agree the practical effect of the position you're advocating today will cause the significant delays in this case going to trial?
Yes, I agree with that.
Does that have to be a factor in the consideration when exercising discretion?
It doesn't have to be a factor. It certainly can be a factor, right? The trial court, in exercising its discretion, is allowed to consider the totality of circumstances. And again, we went out of its way to say this decision can be based upon intuition and judgment, based upon experience, which requires less detailed findings. And it's a highly deferential standard.
Mr. Gutwein, I guess more to the issue before us, when we're deciding whether or not the regular appellate process is wholly inadequate, how should we weigh the delay, especially when it's been asserted that Mr. Allen wants to exercise his speedy trial right?
Again, Justice Goff, as you already recognized, counsel never filed the necessary paperwork to exercise that trial. So that issue is, I would say, not appropriate to seek relief because it doesn't satisfy the basic threshold condition precedent for seeking relief here.
Whether we give relief through an original action or we're concerned that there should have been more process afforded in this issue, a more full process with respect to the issue of removal. What possible harm could there be if we were to go do it the right way? I mean, if we're concerned about the eventual finality of these proceedings, everyone having to go through and do it twice, whether we reinstate counsel, we remand with current counsel and say you need to go through this process, wouldn't that save time in the long run?
Well, let me, perhaps, we don't know, but let me offer
Wouldn't that
this.
protect everyone's interest in finality in the long run?
We really don't know what Mr. Allen wants. And it was not necessary for the trial court to hold a hearing to judge his wants because she was removing counsel. But if this court were to consider reinstating counsel, then the trial court would absolutely be required to probe his interest and make sure that he understood that counsel in this case had engaged in conduct that was detrimental to his interest, as counsel himself has already acknowledged it, and then see if he has a knowing and intelligent interest in having counsel continue that clearly, on this record, has engaged in conduct that's detrimental to his defense. I have exceeded my time, and so I will yield the remainder of my time to my good friend, Ms. Sanchez.
Thank you,
Your
Mr.
Honors.
Gutwein. Ms. Sanchez.
May it please the court. There's nothing clear or absolute about this case, the record, the proceedings that led us here today, the legal issues before the court, or the nature of the rights that Mr. Allen's counsel today seeks to vindicate. There are means through the trial court and the appellate process to untangle complicated questions. This court has repeatedly stated that those are the methods that are far more well suited to such complex issues. The appellate process, for example, would allow a full record in the criminal case, which we do not have here. It would make the parties to the underlying action the actual parties in this case, unlike here where the Attorney General's office is in the nature of something like an amicus, wherein the party of interest is the court, forced to act as advocate in defense of itself. What
would be the harm if because of the necessary delays in backing up and going back through again, reinstating counsel, and if the judge is correct, then that will weed itself out and there'll be a hearing and it'll be done a proper way in the trial court and then come back up?
The state shares the concerns, most especially the Attorney General's office, given our role in original actions, about this court's caseload and the increased use of that. But putting that aside, as Justice Bassett suggested, there are other concerns here. In this specific case, we agree that if any form of relief were to be given that included putting these attorneys back on, it would absolutely be necessary that further proceedings were had. On October 19th, when the judge warned the counsel of her intentions and her concerns, they chose to withdraw to avoid a hearing at which the state was prepared to present evidence that may well have been about an active investigation, evidence that may well be relevant to a full understanding of the conduct that is of concern to the judge. Of course, the summary proceedings in chambers don't allow full challenge, full understanding and elucidation of the concerns. So a complete assessment of what is at issue here and the risks. The risk not only to Mr. Allen's representation at trial and his interest, but the entire risk to the process. Trial courts are not just tasked with protecting the defendant's right to effective counsel. They're tasked with protecting the entire proceedings and the fairness of the proceedings for everyone involved, for the integrity of the entire system, for the reliability of the truth-seeking function, and for the fact that everyone will believe.
Do you agree that with under U.S. Supreme Court precedents, Gonzalez, if there's this mistake made at the front of this case with regard to a defendant's constitutional right to counsel of his choice, that you can go through this entire process and have to do it again if there's a conviction?
Their state is concerned that if you look at what happened on the October 31st, and that is a very ambiguous series of events there, if someone were to conclude that what happened there was in fact Mr. Allen, it's a personal right to choose your counsel, he was in fact exercising it, and that it was wrongfully denied to him, that would be structural error. It is a concern for the state that if those things were to be the way that record was. Now, what's happening that day is itself another unclear and ambiguous thing. Counsel comes and files these appearances. On the face of them, they both purport to be pro bono, but also reassert the resistance to the rejection of the prior waiver and the desire to be reinstated as public defenders, a contingent willingness to be pro bono counsel. Of course, the only knowledge we have of Mr. Allen is, or what he wants, what he knows, what he understands is, of course, secondhand. The choice of counsel is a unique aspect of the Sixth Amendment right. It's completely separate from the right to assistance of counsel, the effective representation, which protects the fair trial right. The choice is about your autonomy and independence. It's a personal exercise. And we need to know that Mr. Allen is in fact the person who was making that choice, that he was in fact competent to make it. There's been many consistent allegations about his mental state throughout the case. And then of course that he has the information he needs to make that as a knowing and intelligent exercise of a constitutional right under the circumstances, including the concerns about his counsel, the other options that he has available to him that he's choosing against, and so on. So of course, none of that happened in this case.
Should we at least start with a presumption in favor of the continuity of counsel?
There is presumption, highly
The default
significant
rule,
weighted.
something like it?
At the end, the desire of a defendant, the state agrees, to either retain his counsel that he's had is a factor a court has to consider and give weight to amongst all of the considerations at play when deciding how to balance all of the concerns for a fair trial, for his representation, to the all of the other issues of efficient.
And then are you aware of any Indiana cases where attorneys have been disqualified on grounds similar to this?
No, Your Honor. In fact, there's a wide variety of cases around the country for various conduct that could be contumacious, violation of court orders, behavior during court proceedings, or ethical violations. The trick here is that we find few cases that involve multiple different types of allegations, which appear to be what the trial court is raising, a pattern of behavior. But again, it's not fully explained because of the abbreviated proceedings below. I think it's reasonable when looking at if that is in fact what the judge means. I think it would be reasonable for a trial court to have concerns greater about the prospective performance of counsel and the effect of their performance on the proceedings looking forward if what the court was recognizing was a pattern of conduct that violated the rules, that tried the case in public, that did not follow court orders, et cetera, et cetera, et cetera. But where any one of those incidents in itself might not
But there's
sufficient.
no other case out there where a judge sua sponte on her own motion disqualified based on her belief in incompetency and gross negligence.
There are cases of disqualification based on the court's own motion, and even in.
But for these reasons, it
but-
could be conflict, it could be conflict, it could be.
The wording the judge chose is unique in itself. Another point that would help with the larger record to explain exactly what the judge means, because of course we presume we're inferring from that choice of words and the particular thing cited by the judge what she meant by analogy to the use of ethical rules, the ineffective assistance of counsel cases, and so forth. But it's not the typical language.
Just so I'm
in these
clear,
cases.
you've acknowledged the risk of structural reversible error if this defendant proceeds to trial with the new counsel that are now representing him. Despite that, the state's going to double down and say, no relief today. Is that right?
No, we don't think it's a writ. There's no order, there's no absolute duty for anything to be ordered by this court. That said, the state does acknowledge that there are proceedings that can continue to happen. If Mr. Allen, in fact, is trying to exercise his rights, there just isn't prevented from doing so, even now.
Tell us more about that. What do you envision? If we go with the state's view and deny the writ today, what do you envision that might happen going forward that would minimize or eliminate the risk that we're talking about?
I see that my time's up.
Saved by the bell.
You can answer that.
Well, no one wants more proceedings. There's no barrier to the filing of further motions. There was no barrier prior to bringing the original action, whether it be motions to clarify the prior orders and then to seek appeal from that, whether it be a motion seeking to exercise and specifically exercise his right to choice of counsel, and then, if necessary, appeal that. There is nothing stopping further actions and motions in the trial court and proceedings in accordance with that. There never was.
Thank you, counsel. Mr. Lehman, rebuttal.
Am I at 7 minutes now? Is that, we don't know? All right, I'll go with it.
It should.
Justices, I would like to begin by correcting the record. The judge says that we don't know what Rick Allen's wishes were, and the Attorney General says nothing is clear. On October 11th, 2023, Rick Allen filed the following. Dear Judge Galt, please accept this letter as confirmation that I have communicated with my attorney, Bradley Rosie, regarding the circumstances regarding the leaking of sensitive information in this case. I am aware that the images of crime scene photos and other related documents were taken by a friend and former employee of Attorney Baldwin at Attorney Baldwin's office. I have discussed with Attorney Rosie the potential impact that the distribution of these documents could have on my defense. Attorney Rosie has also communicated with me that the prosecutor has requested that the attorney be disqualified from representing me in this case. I do not want this to happen. I want Mr. Baldwin and Mr. Rosie to continue to represent me until this case is resolved one way or the other.
We have that letter. We have that letter.
Yes, it's on page 221 of the record, Your Honor.
Counsel, what if we end up agreeing with Mr. Gutwein with respect to court-appointed counsel, but we end up agreeing with you with respect to volunteer counsel? I just want to make sure I understand the parameters of your requested relief. Are you only interested in having them reinstated as court-appointed counsel, or do you have an alternative request for their participation as pro bono counsel?
Our obligation is the defendant. The defendant wants attorneys Rosie and Baldwin to represent him, and he could not be more clear despite what the other side has tried to represent. But to do a half measure is to credit the judge and the attorney general for allowing this to happen. And because Mr. Rosie and Baldwin were the ones who had an absolute duty to protect their clients' wishes, and they did everything they could to do that. To put them back in the case to say you're working for free or that Mr. Allen needs to pay you is to punish Mr. Allen and Mr. Rosie for doing what their ethical rules require them to do, which is to do zealous advocacy for your client. And those gentlemen, when faced with a real tough call, financial tough call, career tough call, they showed up on October 31st and said, listen, our client, he's been clear what he wants. And this is what we're willing to do in order to protect his rights. But to say that they need to go back in and work for free or that he needs to pay them is to miss what happened here, which is the judge had an absolute duty to act, and that is to accept his letter and his representation of what his expectations were, and that I want these gentlemen to see this case to its end. The Attorney General and the judge want to create ambiguity where none exists. We don't have records like this in other cases. This gentleman could not have been more clear on October 11th. There could not have been more clarity on October 19th. There could not have been more clarity on October 31st. And if your court looks at the new filings where he also is waiting for this court to rule because he's confused as to who his lawyers are, we have some clarity here. And to do anything short of putting them right back in where they were when the rights were violated would be a half measure, Justice. So we'll accept whatever the court's ruling is, but I think that alternative there falls short. With regards to Wheat says, where a court justifiably finds an actual conflict of interest, that's when the discretion kicks in. Conflicts of interest are different than these rules that the judge is writing here. Because a conflict of interest, the judge is complicit in the ethical violation because she has two appearances representing both parties in front of her. And they're different because we know that that's a situation where the lawyer hasn't fully and fairly advised the defendant as to what the repercussions are on proceeding forward. Absent a conflict of interest, we trust these letters like October 11th from these defendants. We trust that they understand what's going on, that they have cooperated with their lawyers and developed a good trial strategy and tactic to catch that prosecutor off on his back foot on a trial that was supposed to happen in January, and to have a well-developed strategy of third-party guilt. These lawyers knew what they were doing. They had articulated in 100-some pages of briefing. Here's what we see in this case. We're ready to go forward with trial. So conflict of interest doesn't apply, and that's what WEAK is clearly about. Conflicts of interest are different. And this court would be one of the first court in Indiana for sure, if not the first court in the nation, to say that we treat all kinds of ethical violations like pretrial publicity or the inadvertent violation of a discovery order as something on the same level as WEAK's conflict of interest. That's unheard of, and this court should not be using the original action to create new law like the judge wants us to say here. Justice Massa and Justice Goff, and Justice Slaughter, you'd asked me a question about ineffective assistance of counsel. I'm clouded sometimes by my judgment because the rules that the judge cited here aren't ineffective. But absolutely, a defendant could waive a claim of ineffective assistance of counsel on the record, and that's what our conflict of interest case law establishes. If you pull the gentleman in and you explain to him what your concerns are, what's going on, and make sure that he knowingly and voluntarily knows what's going on and wants to proceed forward, yes, you can waive an ineffective assistance of counsel claim. So if a client wants to represent himself, he can waive his right to effective assistance of counsel if he knowingly and voluntarily says, I want to go forward and do this on my own. So my troubles with answering that question is I feel so passionately, and Mr. Allen and attorneys Rosie and Baldwin feel so passionately that what the judge is talking about here is zealous advocacy, defending the rights of their client, trying to get this thing to trial quickly. And the reasons that the judge is stating in her brief, which are a little different than the reasons on the record, but none of those are what we see as being related to ineffective assistance of counsel, or would even, if proven to be something wrong, aren't going to meet the Strickland prejudice prong. So, but yes, if these things could ever arise, the ineffective assistance of counsel and justices, I'm not conceding that, but if they could, hypothetically, yes, you can bring the defendant in and he can waive those rights. But that's not what we have here. In the end, Your Honors, the judge exceeded her jurisdiction and refused to accept Rick Allen's wishes when she had an absolute duty to act upon them, and there's an emergency that exists. I think when those things are before this court, there should not be a question as to whether original action exists. And there is more clarity than we see in records across this state as to what this gentleman's wishes are. They are undisputed. And I think that the judge had an absolute duty to recognize what he wanted, go forward with trial in January, and this case should be heard in Carroll County today rather than before the Indiana Supreme Court. But I appreciate your time and consideration. We ask you to grant the relief we requested. Thank you very much.
Thank you, counsel. I want to commend counsel on both sides. Just excellent briefing, excellent argument. We will be discussing the case and getting a decision as quickly as possible.
All right. Ladies and gentlemen, this courtroom will be exited in a orderly fashion. Start with the first 3 rows on either side of the courtroom.
And now we wait. Now we wait. How long for? I couldn't tell you. We don't know whether it's going to be a day, a week, 2 weeks. I don't know. But we are now in waiting mode. Flower of Scotland gifted 5 memberships. Thank you so much. Manchester Vicky, True Crime Snoopy. Who else have we got here? It's jumped. Rhonda, Trish, and Kelly. You get a month's free memberships courtesy of Flower of Scotland. Thank you so much. Wow. Now we wait. Oh, dear. Dear me. Wow. I said it was going to be intense. I told you they were intense. Heather Feather, member for 5 months. Yeah, the world is watching. We're happy to wait. We're happy for them to take their time and get to the right decision, to do what's right for justice in Indiana. justice for everybody in the free world. This is not just about Richard Allen. This is not just about the state of Indiana. This is not just about the United States of America. I feel this in my country too. This could happen to anyone. This could happen to me. It could happen to you. It could happen to anyone. This crazy situation has been allowed to get where it has. I'm just absolutely flabbergasted. But we're one step closer to hopefully getting this case back on track. Because, like I said beforehand, if there has to be justice for Richard Allen in this situation before there can be justice for Abby and Libby. Thank you, Momo Shark, for the $4.99. It's very kind of you. Thank you. But, right, how I felt. I'm glad that I watched some of the previous cases from the Supreme Court because I had no idea what to expect, and at least it gave me an idea of what to expect. That, you know, it's not just a 20-minute or 30-minute speech. It's intense questioning. And I did think Mark floundered a little bit at the beginning. He was nervous at the beginning. I think they did trip him up at one point. However, once Gutwein and Sanchez stood up and started talking, they were so much more brutal to them than they were to Mark. They were brutal because they saw everything that I'd been seeing. They made the points that I'd been making. And it's like, yes, you understand. You understand that there's no record. You understand how ridiculous this case has become. And then when Mark got back up for the rebuttal, that was just brilliant. In my opinion, that was brilliant. The way he ended, yeah. So remember his name. His name is Mark Lehman, and it's Cara Weinecke, or Weinecke. I still don't know how to pronounce her name, who have prepared this writ of mandamus and prohibition. So, yeah, I think Richard Allen is very lucky in some respects that people have just taken up this cause and have been prepared to stand up and take this all the way to the Supreme Court of Indiana, because it's terrifying. It's terrifying to think that attorneys of good standing can just be disqualified because a judge decides. And that Gutwein guy, he was ridiculous. He said, I'm going to have to clip it. I'm going to have to clip it and put it in a video. But he said, well, it doesn't really matter that, you know, they weren't inefficient. They weren't ineffective counsel. There was a possibility that they could be in the future or something, the words to that effect. I'm paraphrasing, but it's like, well, anybody. You could say that about anybody in any walk of life, in any job. You know, you can't sack someone for being ineffective when they've not been ineffective, but they might be in future. I mean, that's just absurd. That's crazy town. That's just nuts. So unless Frances C. Gull has got a crystal ball and she can see into the future, and she's got a premonition that at some point in the future, Baldwin and Rosie are going to be an effective counsel, I don't know what to tell you. Unbelievable. Fairy Goddess member for 12 months. Thank God that's over. I know. I was just like, oh God. But once Gutwein got up and they started to grill him, I thought, yeah, yeah. If the justices don't reinstate Baldwin and Rosie, at least the very, very best shot has been given to get this case back on track. There can't be any, I don't know, regrets, or, Mark and Cara have got all this on their shoulders. But I think they've taken on this mantle and they've played an absolute blinder. So if the Supreme Court don't file in their favour, it's not because of them. And I don't want anybody to come back and say that, they were just, fly-by-night numpties who just did everything wrong. No. It was very clear that Gutwein and Sanchez had absolutely no argument. If Gutwein mentioned wheat one more time, oh dear, he just wouldn't listen. He wouldn't listen. She said, have you got anything else except wheat? It's like, no, he doesn't. And he was even quoting wheat wrong. So, I don't know. We wait, and we can dissect this, and we can we can dissect it, but at the end of the day, there's 5 people who are now discussing this, and it's those 5 people who this very case, the future of this case, rests upon. And when Gull's side were asked, well, isn't this going to delay the trial? And yeah. I mean, what more can you say? Oh, and that Sanchez woman, when she was asked a question, and she and she went, oh, my time's up. Oh no, my time's up. That just said it all to me. That just really said it all. It really did. Mummy of Hamsters, member for 17 months. Oh, is it your birthday? Oh, happy birthday. Happy birthday. Another year older. Another year wiser. Oh, dear. Was Richard there? No, Richard wasn't there. No, Richard wasn't there. And I don't believe Gull was there. I assumed Gull would be there, but I don't think she was. She was probably watching and cringing. Yeah, we hope. But no, Richard wasn't there. But there was very limited seating, so I don't know who got a ticket. Yeah, Chief Justice Rush, she was a badass. Yeah, she was. But yeah, Gutwein and Sanchez couldn't have played it better, especially Sanchez. She was very weak. I mean, all Gutwein had was wheat, but she had nothing. I don't really know why she stood up, other than make the case stronger for Richard's side. Wish Gull was there. It would have been great to see her face. Yeah, we didn't see any of the audience, did we? Apparently Baldwin and Rosie were there, but I don't know whether that's true. Apparently they were going to be there. What the hell did Sanchez even say? I don't know. I don't really know what point she had of getting up there. Other than, like kind of repeating Gutwein a little bit, but I don't know. It seemed like she was just there to fill in time. Yeah, was there an argument to disqualify the prosecution? Oh, yeah, that was another good one. how did that arise? I can't remember what question that was, but it was like, well, it was regarding leaks and stuff. I'm going to have to go back and re-listen, like properly, really re-listen. But yeah, like, should she have disqualified the prosecution? It's like, yeah, I suppose she could have done. I suppose she could have. Come on now. I mean, that's like just saying that the judge he might as well just dictate. The judge might as well just decide the whole thing. The judge might as well just be, not only judge, but also jury and executioner. She's not going to play by the rules and just disqualify everyone willy-nilly. Well, just let her just deal with it and disqualify everybody except her and just let her have her own way. You might as well just say that. It's ridiculous. Olwyn, thank you for the €10. Thank you so much. Down Under with Love, member for 16 months. Thank you. How does that have anything to do with what Gull did? Well, and I'm not really sure that anybody really knows what Gull, like, what was her intention? What was her intention? Her intention was to derail this case. But whose idea was it originally? It was the prosecutor's idea. It was a prosecutor's idea. So if anybody should go, actually, not only the judge, but maybe they should look at appointing a special prosecutor as well. Mind you, though, that would delay the trial even further. Maybe Slick Nick will recuse himself. Maybe that's next on the cards. Yeah, who knows? Not so slick now, are you, Nick? I wonder if he's sitting there with his popcorn listening to all of this. Think it's possible Gull was threatened by the real guilty party. I mean, anything's possible, but probably not. I mean, I don't know. I think that's maybe a little bit far-fetched. But then again, 3 months ago, would I have said that any of this would have happened in any of the cases that I was following? No, I wouldn't. So I'm going to just say anything's possible. But I don't think so. That's just my personal opinion. Mandy, member for 14 months. Gull was wrong. Her own attorneys confirmed it. Absolutely. They didn't even have an argument. They couldn't even put an argument together. It was clear in the documentation that they presented that there was no argument. There was like, oh, no, we can't have this because this is not what the Supreme Court does. And this is the argument they were going down. But they got tripped up and they stumbled. And they were asked some real questions on the actual merits of the case. And they couldn't answer them very well at all. Paper Chaser, member for 15 months. Wonder which way Franny thinks this is going. I would imagine that Francis is not very confident. Again, that's just my opinion. But if I was in Francis's shoes, I would be writing my resignation letter as we speak. I would be like, oh, no, you can't fire me because I quit. Because I'm supreme, whatever, judge, superior judge, chief judge in Allen County now. I've got far too much paperwork to do. I can't even be bothered reading this Frank's hearing thing. And oh, look, my boys, Labrato and Scremin, are now being mean. They're being mean and doing their jobs. And oh, no, I can't handle this. So I quit. Oh, and I really don't feel very well. So I quit as well. Quit for all of those reasons. Hopefully that's what she's doing. That's probably what I would be doing. According to defense diaries, they said it will be a quick decision, so it won't be even a month. Oh, no, I don't think it'll be anywhere close to a month. I don't think it'll be anywhere close to a month. I'm thinking 2 weeks, tops. I'd be surprised if we have to wait more than 2 weeks. But again, that's just my opinion. But I don't think there's going to be like a mega long wait. Have I read the Westerman docs that have over 200 pages under seal because of confidential informants and possibly police? No, I haven't. I haven't read those. No, I am going to, though. I just haven't had a chance to even think. Like, Westerman's got a hearing today, hasn't he? He's got a hearing today. So that's one of my jobs. We might do a live on that if it's interesting stuff. I don't know, though. But no, I haven't seen them. Let's wave goodbye to Gull. Yeah, don't let the door hit her on the way out. I think they want to get this trial moving. I do. I think they recognize that the whole world is watching. I really do. I think they understand the issues. I think they see what we see. Just by the way that they were questioning, they see what we've seen. But now it's, they have to dot the I's and cross the T's. They can't just chat about it online, can they? Whatever decision they make sets a precedent for the future. So, they've got to think about that. But at the same time, I think what they can't allow is this to be the precedent, that a judge can do this, that a prosecutor can decide that attorneys get disqualified and then the judge just goes along with it. That's the most dangerous precedent, I think, that any court could set, really. So Westman doc was interesting because of how adamant they are to protect witnesses, considering his charge is a misdemeanor. Yeah. Chad Daybell has a hearing today. There's a lot of hearings going down. Adam Montgomery had a hearing yesterday. Who else has been to court? There was another case that had a hearing. Can't remember that I'm following. Oh, man. I'm really tired now, I tell you. The Wells have court, do they? And the Wells always have court. Well, at least people say they do. I don't know how often they actually go to court. I mean, it's juvenile court. We're never going to know. Sarah Boone. Thank you, Sharon. Yeah. It was Sarah Boone. Yeah, I mentioned her before. Yeah. Due to go to trial in March and been continued again. The judge should just say, listen, Sarah, you cannot have any more continuances. I don't care how many more attorneys you want to go through. Listen, we're going to trial on this day. Be ready or whatever. Chad's lawyer's withdrawing. Yeah, apparently so. Sarah Boone's case is it's unbelievable. Unbelievable. I'm looking forward to that trial, though, because she's going to be such an awkward person. She's going to pull the most ridiculous faces, and I can make some really funny memes for Twitter. I think they're funny. I don't think anyone else does, but yeah, when there's a good trial on, you can make a good meme. Oh, dear. Anyway, right, I'm going to go because I'm really tired now. It's just like my energy has just been zapped. I was all like fired up. I was all like full of adrenaline, and now I'm just like, whew. We wait. Come out as novelist and tell us the truth. Yeah, I will. All right, I will. Thank you. Thank you for the $2. The real novelist is back. For those of you who are a follower of Novelist True Crime, let me just find him. He's back. He made a new video today. Hold on a minute. Just let me share my screen. Are you going to let me share my screen? Yes, you are. Thank you very much. Okay, this is Novelist True Crime. This this is this is who this is who I am really. I'm really Novelist True Crime, and I actually live in Ireland with a husky. But he had a 5-month break, but then he popped up with a new video. So yeah, that's a good thumbnail as well. Yeah, I watched that earlier. So yeah, go and show. If you like my channel, then you'll probably like Novelist as well. He walks through the woods with a husky and talks about probably all the same cases that I do. So if you like my channel, you'll probably like his, maybe. So yeah, little plug for Novelist there. Yeah, take your nameplate, your ropes, and your plant, turn over your keys. Yeah, just go. Just go. You've got 15 minutes to clear your desk. Just go. You're gone. Because, you know, you might not be ineffective now, but you might well be in the future. So, you know, we're just preempting the possibility that you might be ineffective in future. So, bye-bye, Francis. Yeah, go to the job centre and go and find a new career because you're not good at this one. All right. I'm sure she's probably done some cases okay. And, you know, this one, she's just really sucked as a judge. All right, I'm going. All right. So, thank you for joining me. Thank you for keeping me company. Thank you for calming my nerves beforehand. I'm going to go and have a lie down now. And I'll see you all soon. Thank you very much for the donations. You've been very generous. Thank you, as always, to the mods. And I will see you tomorrow. Enjoy the rest of your day. Bye, guys.